I'm recording on this computer as well. So just so everybody knows that we are recording, and that this whatever you say could possibly be something which is recorded for posterity. So, and this is also being broadcast on Facebook Live, so that other people can join in even if they don't have the exact Zoom link. And this particular session, we're back. We haven't had Lunch and Learn in almost a year now, because Lunch and Learn was, of course, something that happened in person. It's something people did in a reasonably small room and where we ate food. So the subject, though, that we picked actually is I think, a very important one, especially an important one for this time. I think a lot of people have understood the concept of mortality more acutely than ever before, and so estate planning is happening now. But estate planning, in many ways, there are legal tools for getting what you want done, but at the same time, both Jewish Torah perspective, and I would say the experience of our two guest presenters, Richard Wenner and Jack Micner, there's, I would say, some life lessons. Having two professionals who are very seasoned in estate planning is really an asset here, because they can reflect on the history of this issue and how it has impacted families and what they've seen over the course of that of their work experience. Where I'm going to start is with the Jewish perspective, and then Richard is going to lay out a little bit of the fundamentals of BC law, and then Jack, I would say, is going to share with us really, I would say, the kind of wisdom that you get when you understand the law and you have practiced the law and applied the law, not just what's written in the act. And so that's sort of the three stages. So let me start with the Jewish part of this, which is family and wealth planning. Now, if I asked you, is there a story in the Torah that demonstrates how family assets can create a very painful rift in the family, what would you answer?
Maybe.
Oh, come on, someone.
I'm sure there is.
I'm thinking of Abraham and the unequal allocation amongst his children.
Okay, you could pick Abraham, but we don't have a lot of detail on Abraham and what happened with Abraham.
Or are we aware of any dysfunction caused by that?
The challenge everyone's facing is that this was a gift in lifetime. Yeah, Steve.
Yaakov and Esav.
Okay, Yaakov and Esav is certainly one, but Yaakov and Esav managed to get along in the end.
Yeah,
in the end of the story, Yaakov and Esav heal their differences and bury their father together.
Right.
The real one, which I guess
King Solomon.
There is a Solomonic. There is, okay. I guess that's true. David's wish. Okay, you guys found more than I was hoping, right? the story of Solomon and his half brother, and the contest for the throne is certainly another example. But I would say the glaring example that everyone looks at is Joseph gets a coat of many colors, and it creates tremendous jealousy within the family. And so even though that was an act of love, it was done out of the pureness of Jacob's heart, it still created a rift in the family. And Maimonides even references that when he talks about this issue, that a person should do everything possible not to favor one child, because look at what happens to Joseph. But the Talmud is very clear about this, and it says as follows. The Talmud in Baba Batra says it says that a person should not transfer his assets from a bad son to a good son. Right? That should be something which is thoroughly avoided. That, again, the Talmud says one should not transfer their assets from a bad son to a good son. So, just giving this color, let's just say there's one son with whom parents have always fought, and he married a woman that they couldn't stand, and he was a gambler, and he was I don't know, he got tattoos, and he did all sorts of things that his parents were really upset with, and for, in whatever way we say, he was not a good son. The other son, he was the Jewish dream. He became, an ophthalmologist. He davens 3 times a day. He's finished the Talmud 8 times, and he gives plentifully to charity. And
I can't put my face in.
he visits his mother every every 2 days.
Oh, I see. Okay.
See, even in that scenario, a parent should not transfer money from one to another, right? The bad son does not get dispossessed. The Shulchan Aruch, the Code of Jewish Law, says as follows. It says, Kol hanoten nechasav la'acherim ve'niach hayorshim. Anybody who gives away all of his money even to charities, and he leaves his heirs without anything, afapi she'ein hayorshin nohagin kashura, even though his sons were deadbeats, his children were no goodniks, good for nothings, which reminds me of the joke, right? Three bubbies sit down on a park bench. One says, Gewalt. The second says, Oy weh is mir. The third one says, Oy, mein Herz. And then the first one says, I thought we agreed we weren't talking about the children. So so even though the children may be bad, the Shulchan Aruch says one should not divert one's assets and leave nothing to the children. Why? It says, Ein ruach chachamim nocha himenu, that the rabbis are very displeased with this. So there's no ironclad law in the 5 books of Moses that writes as such, but the rabbis, I guess in their experience, in their wisdom, say, look, we're giving you a piece of very solid rabbinic advice. And this advice, we may think it is our generation that suffers, but the rabbis are taking this from the Talmudic period. And Rabbi Yosef Karo is codifying it again in the medieval period. And so this is obviously a perennial problem. And he says that the rabbis have found this to be a very distasteful activity. What's more so is that the Shulchan Aruch says, Umidat chasidut shelo laha'id b'tzava. It says, let's say you're called in to be the witness to such a will. You're called in to be the person who signs on the dotted line and says, I affirm that, Chaim Yankel Goldberg is of sound mind and has created this will and testament. So he says that you should refuse to be a party to that will. You should refuse to be the witness to a document that dispossesses a son. Even if it's a case where it's a son who is a wicked son or a disfavored son, a bad son to a good son, one who's behaving well to one who's not, and if someone dies, I'm gonna introduce a word, a very legal term, intestate. Intestate means someone who dies without a will. But if someone's will it's not quite intestate, it's close to it. It says his last will and testament is to the executor. You know what? You do what you think is best. So if that is the instruction, so the translation of that instruction is divide it equally. Now, just a couple of exceptional situations. Actually, let me one summary point and then a couple of exceptional situations. The summary point is I'm going to read a modern codifier of Jewish law, Rabbi Eliezer Melamed. Those who join my morning class know him very well, but I'm going to read you a translation of his words. He says, a father who could be a parent who discriminates between his children, provokes a dispute between them and destroys his family. The deprived child will blame the favored children for flattering the parent and for perverting his relationship with their parent in order to dispossess the disfavored children. And then they will then have a rift in their family for the rest of their lives. His children will also stay away from the rest of the family, and the family will be torn apart. It turns out that even the children he wants to prefer will eventually feel some hatred towards their parent. Why? Because the father was the one who drove the wedge between the children, or the parent was the one who drove the wedge between the children. They may be happy that they inherited a larger share, but towards their father they will feel alienated, because the relationship between their children and the siblings and between parents should be absolute and eternal, a relationship that does not depend on anything. And if they see that their father's connection to them depends on respect and flattery towards him, they will not remember him as a good father, but a man who is very sensitive to his honor, who even with his inheritance behaves in a petty and begrudging way. Rabbi Melamed in another place, basically, he says that that it is unavoidable that the distribution of assets also translates into the distribution of love. And so you don't want to create a scenario where a child who then cannot have a conversation actively with a parent is going to feel that they were not loved in their lifetime. And that's a very damaging thing and something that we would very strongly want to avoid. And so if I could communicate one thing more strongly, both in terms of what I've learned here as a Torah principle, but also in my own experience, nothing creates bitterness in a family like the distribution of assets. That the Torah is very, very strongly favors an equal division of assets, because the failure to do so just causes pain. And if there's one takeaway message from this particular rabbinic insight, is that is very much the lesson. The lesson is that when you favor one child, when you do not work an equitable distribution, you are going to cause pain in your family. And I cannot tell you how many and how bitter and I tell you that you might say to yourself, oh, but my family's healthy. I can tell you I've seen it in healthy people. I've seen grandchildren schlepped into their parents' fight with siblings. I have seen all sorts of horrible things. And really, all of the research, and I would say that we can reasonably agree that our greatest assets are our relationships, and we should not let financial assets blind us to that. But that often happens. And so the remedy to keeping those financial assets from being a blinding force is to distribute them equally, regardless of how poorly behaved a particular child is or how bad your relationship is with them. What about some exceptions? So just two quick exceptions. One is charitable giving. As long as in Jewish law, as long as you leave your children a respectable share, a share that represents some kind of material support, it's very hard to say exactly how much that is. There are numbers that are thrown around in the halachic literature, but I don't think they're really relevant to today's economy. So as long as you leave something reasonable to your children, you can give as much to charity as you want. And so, when Warren Buffett passes on, if he leaves 1% of his fortune to his children, I'm sure he's doing them just fine. And if the other 99% of his fortune goes to charities, that is kosher by Jewish law. So that's exception number one. Exception number two is the only exception that I know of that Jewish faith has that allows, and that is, what if a child completely abandons their Judaism? They become, a Christian. They convert out of the faith. There, Rabbi Moshe Feinstein says there's a difference between a bad son and what halacha calls a mumar. Mumar is someone who has abandoned their faith, abandoned their people, completely strayed in a completely different direction, and they're disinheriting someone because they have left the faith. I don't want to get into all of the nuances about what about marrying out, what about how from a Christian do they need to be, right? There are all sorts of different questions we could ask about what that means, but there is a provision for saying if you leave the Jewish people, that's something that I can't tolerate, and I have to reserve a special category for that. But let's hope that we avoid those kinds of outcomes. And again, just coming back to the most important lesson, the Jewish law has is that a that you have to divide it equally. Now, this brings me back to one other exception. In natural Jewish law, the firstborn gets a double inheritance, and daughters do not get inheritance. Now, this goes all the way back to the biblical context, very different economy, and a very long time ago, Jewish law realized this was a real problem, and it created a different vehicle, and it's called a shtar chatzi zachar. It's called a document of, it really means half of a son. That's the literal translation. What it really is that in his lifetime, or in her lifetime, a parent gives to their daughter a promissory note, which effectively creates a lien, a debt against the estate, and the daughter can exercise this debt against the estate. But she basically turns to her brothers and says, "Look, you guys have the natural Jewish inheritance. Let's come to an agreement. Let's divide the whole thing equally. I'll give up my right in this promissory note. You guys transfer a portion of your inheritance, and Jewish law is happy on all fronts. The children are respected equally, and you have not subverted the natural Torah laws of succession." And so for a very, very long time, literally hundreds of years, if not close to 1,000 years, this type of document has been used to ensure that daughters inherit equally with sons. So that covers most of the Jewish portion of this, the halachic portion of this. We may certainly open up for questions, but now I want to hand it over to Richard, because part of this is ensuring that we also know, if we are actually actively doing some estate planning, how this should work vis-a-vis BC law. So I want to thank both in advance. I want to thank Richard and Jack. They put a lot of preparation into this, and I'm really excited to be able to share this with them.
Thank you, Rabbi. I put together a short presentation, which I'll discuss in just a minute, but I just want to comment on what you've just said. When you talked about allocating more to the wealthy child than to the poor child, if I can call it that. And in my world, you see that, sure, from time to time. But what I see more often is the unsuccessful child being favored over the successful child, creating the same rift. But that's something I see much more frequently. The ophthalmologist who you commented has been successful, goes to shul 3 times a day and is living quite well. The parent will say, well, he's done well. It's the schlepper child who's done nothing with his life. And I just thought I'd raise that with you. The second thought.
Oh, actually, Richard, yeah, that just brings a good point, and I'm sure you're going to get to this, is that dividing equally can mean a lot of different things, because there are different kinds of assets, there are different ways of evaluating them. There are also, people may divide based on size of family, based on anticipated needs. They may also divide things based on which child gave up their profession in order to care for an ailing parent. So the word equally is a very broad word, which definitely needs some sharper focus. But the halakha does not give us a lot of detail about what equally might necessarily mean, and I'm leaving it open, and I'm nearly certain that both Jack and Richard are going to address this issue of equality and how to negotiate that particular issue.
Actually, that was my next point, because equal is not necessarily equivalent to fair for a variety of reasons, like you said. There could be disability issues or other issues which could create an unequal distribution, but which might be quite fair under the circumstances. The next point I wanted to raise, and I have discussed this with you privately, but I thought I'd just share it, is that typically the person who comes to me and says, look, I want to disinherit a child, how do I do that? And I'll then sit down and explain to them, what kind of legacy do you want to leave? Do you want to leave a legacy of love and kindness where they look upon you kindly, or do you want to leave a legacy of division and intolerance where the children and grandchildren don't know each other, or don't speak to each other? And the typical response is, yeah, that's exactly what I want. So, it's unfortunate, but that's the world, it seems, that in which we live. And at that point, there are ways of doing that. I just don't feel comfortable doing it personally. I tend to refer those files out. So let's talk generally. I prepared a short PowerPoint presentation because I was asked to discuss really British or the laws of inheritance if you don't have a will. That's, as we said before, called intestacy. And then I want to talk about the laws of inheritance even if you do have a will. So let's talk here. Let's see. Now, here we go. This is always a challenge to me to see. Whoops, where are we here? Oh, am I still there? Hold on. Am I out?
You're still here. We don't see your
I
screen.
can hear you. I just don't see what happened to the picture. Oh, man. Just a second. How do I go about? Hold on a minute. I will go back into this. Here we go. I'm sorry. There we go. Phew. Okay. So I'm going to share screen. And Rabbi, how did you say I've got the power here? Presentation. We're ready to go. Well done. Okay.
Okay, you're doing it.
Man, this is good. So
you need to play from the beginning. There you go.
Right. There.
On the left, far left.
Thank you.
There you go.
Very good. Okay. So I think the laws of succession and the will's variation rules are really a reflection of what we call the law of British Columbia values, or really is an adaptation of Western liberal values. So I just want to discuss this distinction to dying without a will. What is the purpose of a will? And put in, I suppose, blunt terms, is a will really does two things. One, it appoints an executor whose job it is, that's the trustee, whose job it is to administer the deceased estate after they're gone. They're the person who stands in the shoes of the deceased and looks after their affairs. And secondly, it tells the executor what to do. Okay, and so a will is quite valuable in that way because you have somebody who can make decisions immediately. So what if you die without a will? Well, the first thing is that there's nobody who can make decisions on behalf of the estate until the court has appointed that person. That's a lengthy and expensive process. And I want to point that out because it's expensive, not only in terms of the legal fees, but in terms of the inability of the family to administer the estate. It creates all kinds of issues. And it can not only slows things down, but you can't do what you have to do in order to maintain the value of the estate until that court order is obtained. Okay, so that's the first kind of critical point they need to know for where there's no will. The second is how is the will, and so typically who does the court appoint? And it's typically the person who's the primary beneficiary. And that's the theory there is that the beneficiary, it's in their best interest to look after the affairs of the estate. Okay. And so we'll go through and so who's the primary beneficiary? Well, let's talk about that. The primary beneficiary is how it's distributed. And so how is the estate distributed if there's no will? Well, it depends upon the circumstances. If the deceased left a spouse and no children, you notice I'm using the word spouse and not wife or husband. Spouse is widely defined. But and I'll get to that in just a minute, but if you leave a spouse and no children, well, everything goes to the spouse, okay? And so the definition of the spouse is two people who are married to each other or two people who live together in a marriage-like relationship for at least 2 years. Those are British Columbia values. And what if there's more going on at the same time? You see these things in my practice. They're married and there's the woman on the side or whatever, typically. That creates lots of, it makes life interesting. So what if the one dies with the spouse and children? So the entitlement of the spouse is dependent upon who are the parents of the children. So what do I mean by that? Well, if one dies, typically the husband dies, and if all of the deceased's children are from the surviving spouse, then the surviving spouse gets the first $300,000 from the estate. But if all of the children, all of them, did not come from that spouse, then the surviving spouse only gets $150,000 off the top. Okay. The remainder is then divided as follows. The surviving spouse gets all the household furnishings and 1/2 of the remaining value of the estate. The remainder is divided equally amongst the deceased children when they turn age 19. Okay. So, and that raises a number of issues in terms of administration. If it's a large estate, can the child handle it at age 19? Most cannot. Well, that's my experience anyway. And so, but that is the law. What happens to the matrimonial home? In my view, it's particularly unfair. Excuse me, here we go. The surviving spouse has the option to purchase the home, but they have to do so within 180 days of the court order granting the probate or the representation grant. And it presents for most surviving spouses an almost impossible scenario. To come up with the kind of money required to buy the house is almost impossible. It used to be that the surviving spouse had a life interest, but the law was changed, and that's no longer the case. Okay. So one dies with no spouse and no children, then it goes to their descendants in equal shares. Okay. And what if there's no descendants? Then, hold on a minute, it goes to the deceased's parents equally, or to the surviving parent if there's only one of them. And if there's no parents, then it goes to the descendants of the parents. In other words, the siblings of the person who's died. And if there's no descendants of the deceased parents, then it goes up to the next level to the surviving grandparents. And if there's no surviving grandparents, then to the descendants of the grandparents in equal shares. So it's a little different in British Columbia than in other jurisdictions, but that's the way it works here. Now, there's a caveat to all of this, in that distribution is limited to persons to the 4th degree of separation. Okay, so thinking about it, it goes from parent to child to grandparent to great-grandparent, to grandparent to parent, grandparents, children, only to 4 levels of separation. And what if there's nobody in the 4th level, but it goes to the 5th level? It goes to this guy here. Okay, it goes to the government. So it's a good reason to make a will. So I then want to talk about if you make a will your wishes be honored? And that's what in the law we call testamentary autonomy. How much control do you have over your state that your wishes be honored? Well, the court will go to great lengths to uphold a will, but with certain conditions. It's certainly not absolute. First, we want to talk about the first question that we've asked, did the deceased have capacity? I want to point out that the test for capacity is really quite minimal. If the will maker would have to be established that the will maker understood what he or she owned, okay? B, what he or she, whom he or she wanted to give their estate to, and 3, what the consequences were. Did they understand who it was they're giving it to? So the test is fairly minimal, and every lawyer making a will has to satisfy himself as to that minimal degree of capacity. Okay. The second question that a court would ask is, was there any undue influence? And by undue influence, was there any, did they suffer from a position of subservience to somebody in some kind of relationship, parent, child, or some other relationship where they would be unduly influenced in the decision-making process? As lawyers, we try to minimize that as best we can. Typically, client will come in with family in the waiting room and make sure they stay behind. They come into your office alone, you speak to them alone, and they sign it alone. In fact, the law says that if a beneficiary witnesses the will, that gift is prima facie void unless you can prove that there was no undue influence. So we're always concerned about that. And the third, was there any coercion, which in our law is typically defined as a threat of violence. Okay. And so provided there are none of those 3 conditions, in most jurisdictions, the deceased will be upheld, provided those 3 factors cannot be established. But what's unusual about British Columbia is that it's necessary, but it's not sufficient. Because under the wills variation rules of British Columbia, which are kind of unique to our province, the deceased or the will maker has an obligation to provide not only for his or her children, spouse, but also for his or her children. And I want to point out is that, if I take a look, I've underlined the critical parts here. The will maker, if he dies leaving a will that does not make adequate provision for the proper maintenance and support of the will maker's spouse or children, the court may order that the division that it thinks adequate, just, and equitable. It doesn't say equal. It says adequate, just, and equitable under the circumstances. So under what circumstances? So what this legislation has been around. It just had its 100th anniversary. And it's interesting because it's been interpreted differently over the generations. The Supreme Court of Canada has determined that these rules impose a moral obligation upon a will maker to comply with these British Columbia values. Okay, and so the courts, I'm not aware, maybe Jack or others can provide an example, but I'm not aware of any other legislation which impose a moral obligation. And the law that's generally considered to above and beyond the role of the courts. We're really concerned about imposing legal obligations, but not moral obligations. But here, this is what we have. Okay, and so how is that interpreted? Well, the courts have struggled with this. And in fact, every case is unique because the facts are different and not necessarily translatable to other situations. But I think if I could summarize it, I would say that the will maker has a duty to provide for one's spouse or spouses, okay, even if the marriage was a short one. The deceased has a duty to provide for his or her children, all of them, even if they are adult children. And that's what makes British Columbia unique. In most other jurisdictions in Canada, to my knowledge, that obligation ends at the age of majority, which is 19 in British Columbia and 18 everywhere else. And so this includes children with whom the deceased has become estranged, children who receive a lesser inheritance than their siblings for reasons which the courts find unacceptable. Or for any other reason, children who have been at birth, for example, who were they didn't raise them, but who have not been adopted outside, or other reasons. There are all kinds of situations which can arise. So the allow and what this legislation does effectively is it empowers the disenfranchised spouse or the disenfranchised child to challenge the deceased will on the simple basis that the decision was not adequate or fair. So under what circumstances does this arise? Well, as I pointed out a moment ago, where the deceased does not make an equal division or certainly an equitable division between or amongst the children. What I see a lot is second or subsequent marriages, where the deceased had children from a prior relationship, and the deceased does not provide adequately for either the surviving spouse or the children. And that's the most common scenario that I see in my world. You've got children from the first relationship and the spouse from subsequent spouse. And even at the best of times, there's sparks between them, it seems. And when they die and do not make adequate provision, that's when the legal profession is enhanced, let's say. Where the deceased makes an equal, and third is where the deceased does make an equal division between or amongst his children, but the deceased advanced more to one child during his lifetime to the exclusion of the others. And typically in Vancouver is to help them buy a home, typically. They'll have, to one child, they give $200,000, which in 1990 helped them buy the home. And they'll set aside $200,000 for the other child who 10 years later, or 15 years later, that buys nothing. Okay, or that money is set aside in the will, but it doesn't go anywhere. Where I often see is you talked earlier about the obligation to do charity. And you gave actually, I thought, a great example of Warren Buffett. But where I often see is deceased leaves a whole lot more to charity than to his children. and that's also been grounds for challenge. I want to point out that if there's going to be a challenge, it has to be within 100 or 210 days following the date of the granting of the court order of probate. So these things are designed to be dealt with fairly quickly. So that really ends what I had to say here. Do you have any questions? Perhaps I should hand it over to Jack then.
Okay,
You hear?
all right. First of all, let me apologize in advance for any remark that I might make that runs contrary to our sages or the Torah. And I have great hope that we will soon resume regular services at Shar Tzedek, which will afford me the opportunity to repent for anything I might say this afternoon.
Richard, could you just click stop share on your screen share?
How do I do that? Okay, thank you.
Top right.
Thank you.
Red bar.
Excellent, thank you.
Okay,
great.
so
Okay, Jack, go ahead.
with that introduction, what I'd like to do, as I understand, Rabbi wanted me to do, to talk about a little bit about will planning, a little bit about equality and subsequent relationships, and if there is a little bit of time, about charity. And so let's see what surface we can scratch today. I start with three fundamental principles. Number one, the old legal maxim, where there's a will, there's a relative. Number two, the second maxim, no two families are the same. Number three, if it's possible to have communication in the family, that's really important. In British Columbia, we have what's called total testamentary freedom, which means that you can write a will and allocate to anything, any person or any organization you want. You're not restricted. In France, as an example, if you're married with children and you pass, half your estate is going to go to your spouse. So France doesn't have total testamentary freedom. So in British Columbia, we do. Now, from my perspective, what's really critical in will planning is having the lengthy conversation. And that means that when I meet people for the first time, we spend a lot of time together. I don't do, what's your name? What's your full name? What's your children's name? Who do you want to leave it to? We have a talk. And, at some point in our conversation, I will be asked typically, why do you want to know all this? And I tell them that I want to know about this because I need to know what this family's about. What are the dynamics? And what are the relationships between not only parents and children, but children and children can be very significant. And by the way, I am nosy. That's another story. But it's very easy to ask, how many kids you have, etc. But I don't think you're doing your client a great service doing that. I once had a couple in who told me that they wanted to name all their 3 children as executors of their will. And I told them that, that's going to create some added time. It will create added expense. And it may make things a little unworkable at times because I have to deal with 3 people. And they told me that, they knew that if they did not name all their kids, the ones who they left out would be very angry. And so they were afraid to leave anybody out. So we named all 3 as executors. So again, it's all about that lengthy conversation because it's going to bear on what goes into the will. I may be meeting parents who have 2 children. One is disabled and receives provincial income disability assistance. So in that situation, parents never want their children to lose that benefit. So, if they give that disabled child half their estate outright, eventually a social worker is going to tell somebody, the brother who's not disabled or the executor, whatever it is, me, that these provincial income disability benefits must end. And when the disabled child goes through all their money, then they can reapply for the provincial income disability benefits. But then the question arises, when they reapply, will they qualify? The provincial rules may change. So in this instance, we talk with the parents about a discretionary trust in their wills. And depending on what the value of the estate happens to be, they may want to do half-half. The non-disabled child will get all of it outright, and the disabled child will get the discretionary trust, and that will supplement the income disability benefits. And so that the trustee, and you have to choose a good trustee, by the way, and that trustee will be able to spend money on that disabled child to supplement their living costs. Similarly, a family may have a child who is drug addicted. And in that situation, it's really difficult to deal with. You cannot leave a drug addicted child, let's say a third of an estate, outright, because you run the very high risk that the inheritance will be used or partly used to buy illicit substances, which may lead to an overdose, God forbid, death. So again, you need to create a discretionary trust in the will, and you need to choose the trustee with care. Now, I get asked, I would say probably about once every couple of weeks, how much do you charge for a simple will? And my typical reply is, ain't no such thing as a simple will. And the people who ask that question usually end up with the most complicated wills. It takes the most amount of work, just the way it runs. If a will is simple, it may mean that I didn't ask enough questions, frankly. With that, let me turn to a couple comments on the issue of equality. Now, the equality of distribution in a will, halachic to be sure, is not always easy to achieve. As Richard mentioned earlier, maybe a better word than equal is fair. And that's because there are a myriad of situations. As I said earlier, no two families are the same, and I resist the temptation to assume that they are, or at least some families are the same. Parents, and I think Richard alluded to this as well, parents, in my experience, tend to think first about need. What ought to get, in determining who ought to get what. Parents do not automatically always think of an equal distribution. Now, in Canada, the average family consists of 2.2 children. And I do think that 0.2 is probably for the dog. I don't mean to demean dogs, but we're talking about a typical family in Canada, 2 kids. And so the first question that I would run through with those parents is, what are the kids doing? What are their situations? And so do children's differing situations raise an equality issue? Well, it can. I recently dealt with a family with 2 children, both adults. One of the children was living here, another one was living back east, and the income disparity between those 2 children could not have been wider. The parents felt, and they knew, that one child really did need more of the estate, and they told me to distribute in the will what they wanted, and it was not equal. A couple days later, I got a call from the let me say, the reduced share child from Ontario, and that child, was quite angry that they were not getting an equal share. And of course, that call was from the center of the universe, so I had to take it seriously. So the next day, sure enough, the parents called me, and they told me to hold things for a while. So I did, and eventually it got worked out. So really in any family, there are moving parts. So I think that as a lawyer, and of course the parents need to think carefully about the distribution, what it ought to be. And the other issue is, if you choose to distribute unequally, explain it in the will or in a memorandum, which is a separate document. It is with legal force. It's signed, but it's not part of the will. Why is it not part of the will? Because some families don't want that information disclosed in the will. Keep in mind, a will is a public document if it goes to probate. So they don't want their family situation disclosed potentially to the public. So they put the explanation in a separate document. So that if the will is challenged and it ends up in litigation and it goes to trial, which seems to have become a provincial pastime these days, that explanation will be evidence in the case. Now, there's another important concern that may bear on equality, but also bears on in what way the estate might be distributed. It's not uncommon in families today, but their children, parents, their children who enter relationships, marriage or marriage-like, have a 50+% chance of breaking up. And the point being there that if you have a child who's in a bad marriage, or say that you do not and never have gotten along with your son-in-law or your daughter's partner, what do you do when you're planning your will? And this requires some thought. One option that you have is to settle a testamentary trust in the will, so that that daughter who's in, let's say, a shaky marriage, won't get half the estate outright, but will instead get income from that trust for her lifetime, or maybe until she reaches a certain age when she gets it all. So maybe when she turns 50, she'll get it all. And that step makes it harder, not impossible, but harder for the former son-in-law to attack the will and break up the trust if the breakup actually happens after the parents have gone and the trust has been settled and the daughter is receiving the income. Now, as a short aside, if parents are considering helping their child or children buy a townhouse or a condo or a house, and that child is in a relationship or is about to be in a relationship, take a mortgage. And the reason is that if the child's relationship ends, the parents will get their money back, which they often use to help their child then buy something else after the matrimonial home is sold following the breakup. Now, I referred earlier to communication, and that goes hand in hand with equality. And to me, it's complicated, but parents, if they can, they can't always, but if they can, they do well by communicating with their children. When parents are planning their will, they should, between them, first decide what they want to do with their estates, because, by the way, it is their money. I know often in my generation, children have some feeling of entitlement, not to criticize anybody, but it is the parents' money. They're entitled to decide what they want to do with it. And so they have to make a decision. And once the decision is made, I think it's very useful, whether the distribution is going to be equal or not, to let their children know. I think that one of the, as the rabbi alluded to earlier, one of the worst things that can happen to a child is receiving a smaller than equal or less than equal share of their parents' estate and not knowing why. They may have been a good child. I mean, granted, they may live out of the province, so they may not have the opportunity to visit often enough, but they may have still been a good child. And sure enough, they get 20% of the estate and their two brothers each get 40%. What did I do wrong? And that creates potentially an open wound. So if there is communication, the 20% child may not be happy with the distribution, but at least they were told and they know why. And they can object, but, and they can even launch litigation if they choose, but without being told, it's puzzling. And the siblings may well lose their relationship. And I don't underestimate the hurt that's caused by an unequal distribution. And I expect this is what our sages considered when they reached their conclusion that equality is really halachic and the way an estate must be distributed. The highest probability of avoiding a challenge to a will and litigation is to equalize the distribution. It happens, but it's very difficult to vary a will with equal distribution of the estate. So the next best step to take, if you're going to distribute unequally, is to communicate with the children how you want to distribute it and why. So in other words, if you don't want to distribute equally, if you want to go ahead with unequal, tell your children and put in your will an explanation. And if that issue is discussed in the initial meeting between parents and lawyers, the lawyer will help the parents understand what are the implications of that kind of decision. That's one of my jobs. Now, Richard alluded to this, the rabbi alluded to this, subsequent relationships. I think it's become very complicated, partly, but not only, the result of real estate prices. If we were sitting here 30, 35 years ago, and the parents had a house and $100,000 in the bank, there probably wouldn't be much trouble because the house would be worth maybe $100,000, $200,000. Children are probably not going to fight about an estate worth $300,000. But that house, if it's in Vancouver, is now worth probably at least $1.5 million. And that will prompt a different response to an unequal distribution because, simply put, the numbers are higher. So when two people enter a relationship, if one or both of them owns their home, it's valuable, and understandably, they're going to want to protect it, not to mention their other assets, stocks, term deposits, other investments. So in British Columbia today, there are numerous subsequent relationships, marriages, marriage-like, and I think now there's a third category, and I'm going to call that spouses. And I call it spouses in the sense that the law now is that two people can be in a relationship. They do not have to live together any longer to be spouses. Probably the most important case, Richard knows about it, I'm sure, is called Connor Estate. It goes back to 2017, and it's a case where a police constable and a lawyer who was a defense counsel were in a relationship for about 20 years. The police constable was married. His wife knew nothing of this relationship until 2012, when the police constable left his wife and continued his relationship with that lawyer. Now, they did not ever live together because that lawyer was a hoarder and the police constable could not move in. So now in 2015, the lawyer died. And naturally, what would you expect from a lawyer? She never made a will. So the police constable challenged the estate because the lawyer's sisters said that we're the sisters, we inherit under the rules of intestacy that Richard explained earlier. And so the estate belongs to us. Mr. Policeman, you never lived with our sister. You may have had a relationship, but you were not spouses. And the police constable disagreed. He said, no, I'm a spouse. We carried on for 20 plus years, and I'm entitled. The court went with the police constable and essentially determined that they were spouses. because living together is now one factor only that the courts will consider when taking into account whether two people in a relationship were spouses. And there are a number of other cases in British Columbia that have followed Connor. And so it's important law if you are considering a relationship. And I suggest if you're going to do something like that, where you're not going to live together, and a lot of people do this, they want to maintain their separate residences, but still make an agreement of some sort to protect your assets. Because again, once you're together or in a relationship for 2 years, you can be spouses, and then you have inheritance rights in the estate if the other partner dies. Now, my impression from my experiences are that most people, or at least many people in subsequent relationships, do not plan. I don't have data, but my suspicion is that some of the couples make assumptions that everyone will get along, that one party won't make a claim to the assets of the other, that they love each other, they're not going to do something drastic, and that a written agreement is unnecessary. They don't want to spend the money. In other words, it's my fault. So what they're doing really effectively is putting their assets at risk. In my view, there are a few things that subsequent relationship couples need to know. First, are they bound by a separation agreement or a court order from their prior relationship that limits their ability to distribute in their new wills? Okay. For example, I had a case where there was a separation agreement in existence that required the husband to maintain the former wife as the beneficiary of his life insurance policy. Okay. And so he wanted to override that in his new will and give it to his children and a little bit to his new wife. He couldn't do it. Right. Now, the second thing that the couple has to know is living arrangements. Will they live together? If so, will one person move in to the other person's townhouse? Or will they both sell their residences and buy something together, half-half, or something similar? Will they own it as joint tenants or tenants in common? And what's going to happen if one of them dies? So regardless what they do, they have to give it some serious thought, because what might happen when the first spouse dies? Okay, will the surviving party be able to stay in the house, or perhaps remain only for a certain amount of time? It's a critical issue to sort out, because the children of a deceased spouse sometimes assume that the property is going to be sold, they're going to get their portions, and the surviving spouse is going to leave, or they don't even think about it. But he or she says, no, I need to stay in the property. I have nowhere to go. It's not wise to assume anything. Now, the third item a subsequent relationship couple needs to know is the dynamics. They need to grasp, what are the dynamics? How do the husband's children get along with the new wife or partner, and vice versa? Okay, a poor relationship often leads to estrangement. Not a surprise, but it's very sad. It happens a lot, and that may be accompanied by an eventual change of a will. I know that seniors, parents, they value communication from their kids. And so if relationships are not good, that creates a need to plan very carefully. Okay? Now, fourth, that they need to know, each party to a subsequent relationship might consider gifting assets, some of their assets, to their children, their respective children, while everyone is alive. Now that step not only reduces the size of their estates, but also reduces the likelihood of a fight down the road when the first spouse dies. Now, speaking of which, who dies first is significant, because you need to keep in mind that if, let's say, the husband dies first, okay, his children have standing to seek a variation of his will, depending what it says and whether they are dissatisfied with what they are being given. Now, the children may assume, if they don't know, the law, or they don't know their rights, they may assume that they can wait until the surviving wife or partner dies before they get their portion. But who knows, after the husband dies, will she make a new will? Will she distribute some assets while she's alive to her own children? We don't know. And when she dies, the husband's children do not have standing to seek a variation of her will. So it does happen. The children, as I say, don't know their rights, they don't know the law, and they can end up without the assets that they may have counted on for their own retirement. So the surviving second wife may have changed her will or given assets, as I said earlier, to her own children, so the husband's children may stand to lose. And the other issue is that chances are, if the husband dies first, the relationship that his kids have with the surviving stepmother or partner will fade over time. They may not have been close to begin with while the husband was alive. After he dies, the relationship may fade. The surviving spouse may change her will. Who knows, right? And then the surviving wife could even enter a new relationship. So that further complicates it, probably makes it less likely that the husband's children will get what they expect. So this doesn't sound like the Brady Bunch, does it? I don't think it does. So a subsequent relationship couple, I think they owe it to their kids and each other to at least make wills or make a plan. And they should also consider making what's called a mutual wills agreement. I talk about that all the time, and I always recommend it. And it's an agreement that says in so many words, if I survive you, I won't change my will. Okay. Now, that's really useful where children are minors and the party wants to protect them. Okay. And
Jack?
most spouses would say that if they died, they wouldn't expect their surviving spouse to be alone forever, but they would want their assets to go to their children. They don't want assets to go to a new spouse at the expense of their children. Other than that, I think that every subsequent relationship couple, in my view, should see a lawyer to discuss what are the implications of their relationship. Again, 2 years after they enter a relationship, they become spouses. Each are eligible to inherit if their partner dies, and if no will, the surviving spouse will certainly inherit under the rules of intestacy, as Richard has told you.
Jack?
Yes.
I think maybe there are, as you pointed out, no two families are alike, and I just wanted, before we run too far out of time, to see if people had questions that they might want to ask you or Richard or me, just to give that make sure we give that opportunity.
I have a question to Jack, similar to what you're talking about. What I think you call it spouses. I can't remember what you called it. The third category of relationship. If, let's say, an example, two people live in the Louis Briar, right? They're both, their spouse had passed away, but they've been they don't live in the same room, but they're like a couple. They've been a couple for several years in Louis Briar. What happens when one dies? Does one of them have a claim on the other?
Well, I think that gets really complex because if they're in the Louis Briar, I think that, as Richard alluded to earlier, the first question is one of capacity. And the second question is, have they made wills already? And if they don't, Is it coming to my attention
No,
or
leave him
Richard's
alone.
attention because they want to make a will? And if they do, it's my job to discuss with them. Let's say they do have capacity to discuss with them, how long they've been together, what are they doing in their lives. The court will look at many different categories and many different factors. For example, the court will look at things like, are they having meals together? Do they have intimacy? Do other people view them as quote unquote a couple? Do their children now know them to be at least friends? And then so if one of them dies and the other says, look, I need some money to pay my Louis Breyer costs because my partner here in the next room, started a year and a half ago, started helping me with my monthly dues because I don't have enough. And let's say she never had kids. So his kids are now shocked that she's making a claim to his estate. But the truth of the matter is that, this may have been carrying on in the Louis Breyer for, let's say, 4 years. And the court may well determine that, there no issue of capacity. He had capacity. And by the way, as Richard said, on the scale of capacity, the second lowest is making a will. You don't have to have a whole lot of capacity to make a will. It's not like making a commercial agreement to develop a condo tower. The only level of capacity that a person needs to have lower than to make a will is to marry. So the two people living in the next rooms in the Louis Breyer may well have capacity. They knew what they were doing. They were in this relationship, excuse me, and they may well have established a relationship so that a court would hold them to be spouses. And so it would be my job or Richard's job, seeing that couple, to canvass with them and make sure that there's an understanding that, yes, these people have capacity, and yes, they've been carrying on for, let's say, 4 years. And so the wills could be made in such a way that they're understood to be a couple. And the lawyer might then go ahead and say, look, I want a medical report because before I write this will or these two wills, I want to make sure that a doctor's rendered the opinion that these two people have capacity. And so the lawyer may, meet with the doctor who, let's say, is one of the doctors who comes regularly to the Breyer, knows these two people, and tell me, yes, there's no doubt that these two people have capacity. I can tell you this story, I can tell you that story, and then I get a one-page medical report, and I say, okay, fair enough, I'll write the wills.
So Jack, let me, and Richard, I want to ask you a question from a slightly different angle. But this comes back to maybe what I would consider one of the most important overarching themes. If a set of parents come in and, as Richard said, they want to dispossess a child, or they want to cut someone out of the will, what have you found to be the most effective strategies for getting the families to consider the broader legal and personal consequences?
Maybe I can just respond to that. One thing that I neglected to get to in my talk, I missed the last slide, and that is not exactly answering your question, but responding to it in a different way. In that all of this, there's a giant elephant in the room. All of this can be avoided through the use of trusts or designated beneficiaries. If you're determined enough, there's a way to avoid this whole wills variation regime altogether. And I think that has to be understood. And much of this litigation stems from people who haven't planned to implement their wishes as they want them to be implemented. And yes, the consequences can be devastating to the family, but it can be done through an avoidance of the litigation process in its entirety. And I think that has to be stated. So what do you do when people want to implement this dysfunction, which will go for generations? And it's pretty hard to convince people not, I mean, you know, you suggest all the things you suggest. They should have communications with their children. They'll tell you those communications broke down years ago. You know, you say, you know, do you want a, as I said before, what kind of legacy do you want to leave, and they don't care. You know, so, you know, so how do you resolve that? You can recommend counseling, but by the time they come to the lawyer, they're beyond all of that. So in answer to that question, what can you do? I'm not sure what we can do. Okay, that's the really. Jack, what do you do?
Rabbi, there is case authority on the topic of the estate strip, and the case that is I would call the leading case is called Maudsley versus Meshin, and that goes back roughly 5 years. It went to the Court of Appeal. It was about a woman who, with her husband, ran a family business for a long time, and the husband died, and she ended up in a relationship with one of the people that had worked with the family in a consulting kind of capacity. And long story short, she was filling him in as this went along, but she had capacity, and she had a series of meetings with advisors, accountants, lawyers, and started transferring assets to her adult children who were also involved in the family business. And when this gentleman who entered a relationship with her reached the point of seeing the will because she died, he challenged it. He was not disinherited, but he certainly didn't get the lion's share of the assets. But the court held, and it was upheld on appeal, that she could take her assets and distribute it to the people that she wanted to while she was alive. And that Maudsley case has been followed. So one of the strategies, as I alluded to a few minutes back, is transferring assets to children while you're alive. Now, what are the other options that you have? Well, as I said, if the family, or the parents, let me say, are steadfast in their decision to disinherit or to give one child a reduced share, I'm going to canvass with them, have you met with that child to let them know? Have you given them other assets while you were, let's say while he was younger? For example, did you pay for his university education, but you didn't give her any money because she didn't go post-secondary, she went into a job, et cetera, et cetera. So that's one issue that can be canvassed. The other issue is, as Richard said, do you give her, as the designated beneficiary, your RRSP proceeds or your RIF, et cetera? Have you made an insurance policy and designated this one as the beneficiary? One of the other strategies is, look, if you don't want to give 1/3, 1/3, 1/3, you may want to at least consider giving them, instead of 33%, if you give them 20%, then you get into things like the child is going to say, well, it costs too much to litigate. I'd rather take 20% than take my chances in court and maybe go up from 20 to 30. That's one example, the cost of litigation. So, parents come into me with, sort of more hardened attitudes. So it's unlikely that I'm going to convince them to go from 0 to 33 1/3%.
I see. But so if I understand you correctly, you might say to a parent, look, you want to send a message, give them 20 instead of 33, but don't go to 0.
That's one of the options. And the other option is that, if they say, no, look, I really, you don't understand what I've been through for 40 years. It's been extremely stressful. My other son has helped me get through all this. There have been all kinds of problems, the police, So then I say, well, you have to explain it to them, or at least you have to put in a lengthy explanation in the will. And they tell me, go ahead.
I see. I want to maybe we have time for just one more question, but before we take that question, I just want to thank Richard and Jack for sharing their wealth of expertise. I can tell you that I prepared before with them, and I still find that the amount of information here was actually very staggering. The good news is it is being recorded, and it will be put up on the synagogue's YouTube channel, and probably you'll be able to find it on our homepage as well, so that if you want to go back and assimilate more of this information at your own pace, that availability will be there. So if there's one last question, I think we have time for that.
I have a question.
Go ahead.
Either one of the lawyers. My husband and I moved here from Ontario about 4.5 years ago, and our will was drawn up in Ontario, our wills. And one of the executives of our estate is a daughter who lives in Ontario. Is there a problem with that? Do we need to redo our wills here in BC?
Richard?
Look, in the event of your untimely death, that will would certainly be accepted in the British Columbia system for probate. But where you might have difficulty is that the law of Ontario is a little different than BC. And just the circumstances may be different. The appointment of the executor and so forth may be not appropriate or no longer feasible. So my recommendation is that you have it reviewed by a lawyer, and they'll let you know whether it's still functional or not. That's
Yeah, I would say this. First of all, if you're still Leafs fans, you're still welcome in my office, but I hope you're Canucks fans now. But having said that, I would say with Richard, it is useful to have a will reviewed like that by a lawyer here, just to make sure that the requirements in British Columbia are met. I would say in all probability your wills are okay, but at some point it is worthwhile. The other issue is in the pandemic, it might be really difficult for your daughter to act. God forbid something should happen to you during the pandemic, with Ontario in lockdown now. So, you might want to consider, for example, something like adding an executor who's in British Columbia if you have somebody you can appoint. So just to keep that in mind.
Yeah, thank you. Thank you. Actually, we do, because 2 of our children live here in Vancouver. Thank you.
Then you're fine.
Once again, I want to thank both Jack and Richard and everyone for joining us. And once again, this will be something that that will be recorded and available. I'm looking to revive our Lunch and Learn program with various different subjects, and so if there are others who want me to address other subjects, and especially things that dovetail with either federal or provincial law, I'm trying to make this a bit of a partnership so that we educate lawyers. And by the way, lawyers, we are registered for continuing education credits, so you can submit for that and get that satisfied in this. And I would say that Jack and Richard definitely gave us excellent education, and I only want, Jack wanted to know if he had the klap al chet for anything he said in terms of contravening Jewish law. My only recommendation is that if you are currently married, please do not go find a lawyer on the side like the constable. One partner at a time, I think, is what we're advocating from a Jewish perspective. But aside from that little piece, I think it was all really very good. And I think if I had to sum this, I think the 3 summary points. One is try and keep it fair to all the children, or equitable to all the children. Number 2 is communicate. Number 3 is you want to make sure that you are well prepared, and that you should not assume that you have a boilerplate family, that every situation is unique, and you need to prepare for all of those, all the eventualities.
Rabbi, thank you for the opportunity.
Thank you.
Pleasure.